Thank you very much indeed. It's a great honor to receive this prestigious award, and I'm conscious of that. I want to say immediately that there are many people in our country who have done much more than I have done in the struggle for human rights and justice, a struggle led by two lawyers, Nelson Mandela and Oliver Tambo, who suffered great privations as a result of their efforts, followed by many others who suffered great privations. And I need to acknowledge that at the very beginning of the remarks that I'm going to make. I think I should also let you into a secret. I was asked to speak to you tonight for about 15 minutes. And I carefully prepared a text, very nice text, and I put it into a brown envelope, and it was going to be for 12, 13, 14 minutes. And when I was sitting down here a few moments ago, I picked up the envelope, and apparently I brought the wrong envelope with me. And so, textless, but very appreciative of you and all that you have done. I'll make a few remarks which perhaps will be a good thing, because the hour is late, and it may be to all of our advantage not for me not to talk as long as I might otherwise have done, though it's of course very difficult sometimes if one has asked to speak for a brief moment. You say, I haven't got the time to prepare a short speech, so I don't know where this is going to take me. But what I do want to say is this. I wanted to start, really what my remarks were going to be and will be, they were directed to for the struggle for justice in South Africa, the role of lawyers and courts, or the role of lawyers rather, in that struggle, and the importance of the rule of law. So let me paint a little bit of a picture of South Africa under apartheid and of the courts in the country at that time. The apartheid was really the legacy of 3 centuries of colonialism and white rule. A legacy which came out of British colonialism and was entrenched when the imperial government established its new dominion in South Africa and vested the franchise exclusively in the whites. And the great majority of the population, a population of representing about 80% of the total population, were disenfranchised. And what happened over a period of time was that the white parliament used its political power and its economic power to further its own advantage and to marginalize the position of the great majority of the country. And under apartheid, that became institutionalized. Laws were passed, and laws were passed to entrench racial discrimination and to make it a pillar of the country's policy, to such an extent that the president of the time, Hendrik Verwoerd, made a speech in which he said, everything is important, but what is most important as far as we are concerned is the color bar. It is more important than anything else. And so what happened was that laws were entrenched to entrench discrimination, to marginalize the majority of the population, to force them into approximately 20% of the land. 80% of the population went into overpopulated, underdeveloped areas known as homelands, euphemistically. Giving it a name, a homeland, made it sound good where it was really grossly overpopulated, underdeveloped, and impoverished. And those who were allowed into the cities came there and were perceived as temporary sojourners in the cities. Many were not allowed to be accompanied. Many were only allowed to come as workers, as so-called migrants, under permits. And others who were living there for a period of time were forced into overpopulated ghettos and not allowed to own property outside of those areas. And laws were passed to entrench discrimination. Now, at that time, our Constitution was based upon the English law that we had inherited, based on the doctrine of parliamentary supremacy, which meant that courts could not interfere with decisions of Parliament. Parliament was supreme, and no matter what Parliament did, if it took away the rights of people, courts would have to enforce that law. That which may have had some legitimacy in the United Kingdom, lacked any legitimacy in South Africa, where the Parliament was a parliament of a small percentage of the total population and didn't represent the interests of the great majority. There was, though, space within the legal system. Space because we had inherited the British system of administrative law, and though supremacy of Parliament existed, the doctrine of legality and certain principles of administrative law continued to apply. And so though one couldn't challenge parliamentary statutes, it was possible to challenge practices, executive action, and subordinate legislation. Those could be challenged on the basis of administrative law principles and the doctrine of legality. Initially, challenges based on those lines, which were successful, were met by responses from the central government passing laws authorizing discrimination, vesting vast discretionary powers in the hands of the executive, and passing laws to, in effect, deprive courts of jurisdiction over certain matters. As opposition to apartheid persisted and grew stronger, draconian security legislation was put in place, making provision for the banning of the political parties, making provision for detention of leaders, detention of anybody really who operated to the anger of the state, detention without trial, initially for 90 days, then for 180 days, and then indefinitely. Detention incommunicado, passing of laws stripping the court of jurisdiction to order habeas. That led to torture, as it inevitably does, and really to a state in which those leading the opposition were faced with great privations. At the same time, there were still spaces within the legal system, spaces in which you could challenge practices, and there was an ongoing and continuing struggle through the courts against the actions of the executive. Claims were brought against the police for wrongful arrest. Claims were brought against the police for torture. Subordinate legislation was challenged. Trials of political prisoners or political persons were fought vigorously. Very often, if you take the case of the great trial of Mr. Mandela, which was a trial in which he and the leaders of the African National Congress were sent to jail for life, they turned that trial into a trial in which apartheid was put on trial. And they then, the trial became one where the state charged Mandela and Mandela charged the state. And it attracted great publicity and gave a great opportunity to Mr. Mandela to state the reasons for his resistance to the regime and why there was such great injustice within the country. And so there was continually throughout that period an ongoing struggle through the law. Ultimately, as you know, we reached a settlement.